Disorderly conduct or an overreach of justice? We're going to talk about Minnesota versus Shiloh Hendrix today on No Contest, the Kolsrud and King Report. I'm Claudia King. I'm here with Josh Kolsrud. How are you, my friend?
Hey, it's Friday. TGIF. Two great cases we're going to be talking about today. I know that our listeners are going to have a heated debate on one side saying that this was a travesty, and the other side saying they needed more justice for both cases.
Yes, I think you are 100% right. So let's just jump right into it. We're going to start with Minnesota versus Shiloh Hendrix. Do you want to tell us about the case or do you want me to tell us about the case?
Yeah. So this case took place earlier this year. Shiloh Hendrix was at a public park with her daughter, and she was there during the day, and expected just to have a nice day out in the park. And lo and behold, during that expectation, a 5-year-old autistic kid came over and stole some applesauce from one of the pouches on a diaper on a bench. And Shiloh saw this happening and chased the 5-year-old, and it's pretty clear she didn't know that the kid was autistic. And she began yelling at the kid and using some colorful language, reportedly saying the N word, directed towards the 5-year-old. And the latter half of this was recorded by the child's father. And Miss Hendricks was still angry when the recording started, and she did not like the fact that she was being recorded, and she directed her anger towards the father who was filming her, and she continued to use the N-word at him. She flicked off the camera, and this verbal tirade lasted about 30 seconds to a minute long. At least that's what the recording is. The father did not immediately turn in Ms. Hendricks. He contacted the NAACP 10 days later, and they then responded to him that he should contact law enforcement, which he did, and that's where these charges came from. Now, Minnesota had several options on how they could charge the case. They decided to go with the easiest for conviction, which is disorderly conduct. And as a former prosecutor, I can tell you disorderly conduct is one of the easiest charges to convict somebody of. All you have to do is disturb somebody's peace out in public, and that's basically it. They did not charge a racial component with this case. They could have attempted to do that, and they chose not to. They could have charged hate speech crimes, or at least attempted to do that. And again, they did not do that. They took the easy road out, the road that's least likely to be successfully appealed. And this case then went to trial. Miss Shiloh Hendricks did raise around $800,000 for her defense. She had a very competent defense attorney, and they went to trial, and the verdict came out today. The first charge of disorderly conduct, where the victim was the 5-year-old autistic child, was not guilty. I think the jury saw that this lady was spontaneously reacting to a perceived theft, and they were forgiving of her conduct for that crime. However, they were not forgiving for what her attitude and words were towards the father who recorded her, and they found her guilty of count 2. The judge then sentenced her to community service, and she had to pay a maximum fine of $1,000, and she has a 90-day jail sentence hanging over her head if she doesn't timely comply with the court order. So, having said that, this case has certainly made the rounds on social media, and you have half the public saying that what she did was freedom of speech and she shouldn't be punished, and the other half saying this was hate speech and she wasn't punished enough. Claudia, what's your take on this?
I'm a little conflicted, Josh. I have to tell you. I want to start with the disorderly conduct, and I think you're 100% correct. It's the easiest thing to charge, and I actually looked it up for Minnesota. So 609.72 subsection 3, I think is what they were leaning on, engages in offensive, obscene, abusive, boisterous, or noisy conduct, or in offensive, obscene, or abusive language tending reasonably to arouse alarm, anger, or resentment in others. So I see where this offense does fit that subsection. My question is this, and this is a question that a lot of people ask time and time again, and I'm sure people are going to be angry at me for asking it, but I'm going to ask it anyway because that's what we do around here. We ask the hard questions, right, Josh?
All right.
In the video, the father also uses the N word.
Mm-hmm.
So, why is it okay for him to use it and not for her to use it? And I know the easy answer is she's white and he is black. But if a word is truly offensive, isn't it offensive no matter who says it? What do you think?
So I'm going to put on my prosecutor's sunglasses here. They're
Love it.
sunglasses, and they're not clear glasses because I'm a defense attorney now. So they're a little shaded. But I'm going to pretend I'm still a prosecutor, and I'm pretending that you're a judge asking me this question, an angry judge
Love
saying,
it.
prosecutor, why did you bring this case before me? And I see this contradiction. And my response to you, Your Honor, is this: that we did not charge this case because of any single word. Ms. Hendricks could have used any offensive language in this context and still be charged and would have been charged with the same crime. Had we prosecuted her for using the N word, we would have charged her with a hate crime, which we did not. We specifically did not do that because of First Amendment grounds. We didn't think that we could overcome the First Amendment challenge to freedom of speech for punishing somebody for using a single solitary word, maybe used it several times. What we did do, though, was prosecute a woman who was disturbing the peace of not only his father, but a 5-year-old autistic boy, using racial epithets, flicking off the camera, and yelling and disturbing the peace of somebody who was just recording her in a public space. So I think that's the prosecutor's position, that they're not punishing somebody for using a word. It's the context as a whole. When looked at as a whole, you're disturbing the peace of these two people. Now, of course, the jury disagreed and said that she was only guilty of disturbing the peace of the father. I think that the way that a judge or a jury would look at this would be that the father was defending himself, verbally, of course, to the aggression of Miss Hendricks.
As the judge, I'm going to say that defense's motion to dismiss is denied. I
Thank you.
love how you put on your shaded prosecutor lens there. And I love how you explain that, Josh, because I think a lot of people are focusing on the word, and it can be easy to tunnel vision and say, well, it was just because of that word.
Yeah.
And it's really bigger than that.
As a defense attorney, I would have been much more offended had Ms. Hendricks been charged with a hate crime. There are a couple of famous cases dealing with this. And famously, there's a case called Chaplinsky versus New Hampshire, 1942 case. And in that case, the Supreme Court ruled that fighting words are those that, quote, by their very utterance inflict injury or tend to incite an immediate breach of the peace. Words directed at a specific person that are likely to provoke a violent reaction from that person. And that is really what this case hinges on for a lot of people. the N word to the vast majority of people, does evoke a violent response oftentimes. And when you're a prosecutor dealing with a very general crime of disturbing the peace, it really is one of the easiest crimes to prove. It's exactly what it sounds like. You're disturbing somebody's peace out in the public. And context matters. Where you're in this public park full of kids, you have an autistic 5-year-old, and the 5-year-old should have been watched better by his parent, who should have been parenting, and probably should have apologized on the behalf of the 5-year-old, and then help Ms. Hendrix get her applesauce back for her child. That didn't happen, and I think that a lot of people sympathize with Ms. Hendrix in that scenario. But I think that where she went overboard was that once the situation was over with, her verbal tirade then transferred to the father who was filming her. And, that's where the law steps in and says, all right, you stepped over the line, you're disturbing his peace, you're guilty of a misdemeanor.
So, what I'm hearing from you, because we know that Lady Justice is wearing a blindfold because we're not supposed to consider race, sex, creed, color, any of those things when we talk about justice. So, in your opinion, the fact that she's white doesn't really matter in this context. She could have been black, orange, green, purple. Purple would be weird. And she would have still been guilty of disorderly conduct. Are those your thoughts?
Yes. And, race isn't a factor per se. However, you can't ignore it either. It's different. Let's say if a black person says the N word to a black person, I think that's a fair statement. Where in that context, most of the time, you're not going to feel as offended if you're a black person. And again, I'm not trying to speak for black people. I'm just saying what I observe. However, if a white person says that to a black person, I think that we can all use our common sense and say, well, that is used to provoke, a response in a way that isn't the same if it's black on black. So I think that context matters, and there are racial components, but that doesn't mean that it's based on race. You have to look at the intent of the parties. What is her intent on saying this? Oftentimes when you hear that word among black people, it's used in a friendly tone. Here, it wasn't. It was used in an angry tone, and it did have a racial component to it to evoke a violent or an aggressive response, to say the least.
Do you feel like they found her not guilty on the one against the son because that wasn't recorded, because it was more of an excited utterance in that moment and she had more time to think when she was dealing with the dad? What are your thoughts on why they split the verdicts?
Yeah, I've seen this before in trials, both through the bench and jury trials, where juries are more forgiving about people's conduct when a person has a legitimate perceived wrong. Here you had a 5-year-old child who's not being parented very well and steals her child's applesauce, and the parent who is supposed to be watching the 5-year-old isn't doing anything to help. I think that most people in that situation would have been annoyed at the very least about the situation. The difference is how you respond to it. Now, it's easy to say how I would respond looking back at this, 4 months later. And I'm not a mother either, and I never will be. So I don't know what that's like, but I can say that juries are forgiving about that type of conduct. What they're less forgiving at is when there isn't any provocation when you transfer your anger from the 5-year-old child to the child's parent who's filming you. I mean, yes, it's still annoying. However, the theft has already abated. It's already gone away. And I think that the jury decided that they weren't going to forgive that action because it was no longer reactionary. She's an adult. She should have not carried on that aggressive demeanor in that situation the way that she did. And I think that they probably made the correct decision that she disturbed the peace of the adult that was filming her after the theft took place.
Some people are very protective over their applesauce, Josh. I mean, I love a good applesauce. I don't know I would take it to that level, but maybe it was one of the organic brands that's very pricey.
It definitely had some cinnamon in it, for sure.
It had to, and maybe the chunky, perhaps.
Mm-hmm.
Do you think this case is going to set a precedent, maybe in Minnesota, maybe across the nation, where people are going to be paying more attention? And again, we're not focusing on her specific language choice, though that is a piece of it, but we're going to see more filming and we're going to see more people wanting others to be charged with disorderly conduct when they could just walk away.
I think that it might have a little impact, but not very much. And I'll tell you why. It would be one thing if the Minnesota's, if their prosecutors prosecuted this case as a hate crime. And, let's say hypothetically, Ms. Hendrix was convicted of a hate crime because she used the N word towards the 5-year-old and towards the adult father. In that scenario, it would set a precedent in a dangerous way, and it could have allowed and encouraged other states' attorneys to do the same thing, to expand the hate crime laws to include specific words for specific races who use them. But that's not what they did. They punished the context and not the word. And because it's just the context and not a specific word that's being punished, I don't think that it's going to have very much of a difference going forward on how cases are charged. Obviously, it's a very interesting case because it's unusual that something like this is charged. But I think that on a technical level, the prosecution was correct that this is a crime when you look at it very technically on a piece of paper about whether or not at least the child's father's peace was disturbed in this public place.
So, totality of the circumstances, as you mentioned earlier, it's not one piece of it, it's not one word, it's not one action, but the totality of the circumstances are what led to the charges and the one conviction.
Exactly. She's not being prosecuted solely because she said the N word towards the 5-year-old or the 5-year-old's father. It's her entire action from beginning to end, flipping off the camera, yelling, aggressive language, trying to provoke a reaction from the person that's filming her. And that, again, regardless of what specific words she used, is disturbing the peace of those around her. And I'm not surprised that a prosecutor picked up this case.
Anything else that we need to talk about with Shiloh other than she probably shouldn't go to that park anymore and maybe needs to take an anger management class?
Yeah, only that, I think that when we all have the same facts, most of us can conclude what we think is common sense and reasonable and just. And it's unfortunate that you have two different narratives here that really stoke the flames and prejudices of everybody on every side. And I don't think this should be a case where we're at each other's throats about what's right or wrong, because at the end of this is not a First Amendment case. This is a disturbing the peace where hateful conduct was not prosecuted. And both sides seem to think that it was when it really wasn't. Minnesota could have done that, and they chose not to. And I applaud them for that. They acknowledged that there was a First Amendment defense here that would overcome any type of hateful prosecution, any type of hate speech prosecution. So they didn't do that. And I think we should applaud, Minnesota for not going that extra step and, then really creating a racial divide here.
Well, let's talk about another current case that has also created a pretty big racial divide. Nolan Wells in Mississippi, who went with friends to Horn Island, I believe, on July 4th to party with lots of people, tons of people there. And his friends apparently left. Allegedly, their boat was taking on some water. So one boat decided to leave. I think his phone was on that boat. They left without him. And a couple days later, he was found face down without a shirt on. I just want to make that clear. That has been misinterpreted. No shirt, only swimming trunks, dead.
Yeah.
So there's one camp that says he must have been killed by his friends. There's a camp that says he probably drowned. Maybe he was intoxicated. And then there's a camp that I'm in that we don't know yet because we don't have all the information. But this case is creating a lot of issues, Josh. Give me your first impressions of how the case is being handled.
Well, first of all, I think part of the reason why this case is having such a negative impact on two different sides, those believing that there's a racial component here and those saying that, that there's not, is because of the way that this case was handled initially. You had this small town police department, and that's not to say that small town police departments are bad or anything, but this particular one had, to say the very least, some missteps that that they should have avoided, some self-inflicted wounds, right? Where they came out and said soon after his body was discovered that there was no evidence of foul play, and that there wasn't foul play. And that's just not something that you should say in that point of investigation when it's inaccurate. You do not know whether or not there was foul play. And I think that most people looking at the facts at that period of time, using common sense and reasonableness, would be like, you're wrong. Why are you saying that, officer, when common sense says we don't know what we know? And when you say something so dumb like that, and I hate to say that about law enforcement, it's what creates this entire controversy. And I feel for the parents. They love their son obviously tremendously, and they want answers. And when they see somebody in the position of power, such as this law enforcement, small town law enforcement, say something so ridiculous about an ongoing investigation, I can't blame them for thinking that something is happening that's nefarious. However, just because law enforcement does something in the media that is a huge misstep doesn't mean that there was foul play either. And let's talk a little bit about that, and then we'll do a deep dive. And that is, how do you determine that there is foul play? Well, you look at the evidence. You look at what evidence you have, and what evidence you don't, and what evidence you wish you did have. And here, why don't we go through what we do know? Claudia, what do we know about the evidence of foul play in this case including what we don't know from the day of events. And I'll help you with this. So there was a 4th of July party. You had thousands of people out there, right, in Mississippi near an island, and you had groups of friends. There was reportedly 3 different boats of friends that all knew each other, and by all reports, they were all legitimately friends. They were not enemies. They weren't just colleagues. They weren't just acquaintances. They were friends from high school. And I don't think anybody is saying otherwise. However, there are allegations that these friends killed him. And we don't have that evidence yet. So during the time that all these people were on the island, they were drinking, and apparently most people left their cell phones on the boats. And during the time on the island, the victim, again, reportedly, and this could be just hearsay, but got into an altercation with somebody there. I don't know anything more than just the word altercation. I don't know if that means physical fight or shouting or who was involved. I do know that that is being investigated because that's a huge lead. But at some point, people decided they were going to leave. And the victim, the boat that he was on, had some mechanical issues. And they had to improvise and decide how they were going to get back to the mainland. And for whatever reason, and again, we don't know the reason, the victim decided to stay on the island. And his friends left him on the island. I don't know if there were certain friends that stayed on the island with him. I don't know if he met a different group of friends while he was there. I do think that it would be suspicious if all of his friends left him there on purpose and he didn't know, and the victim didn't know anybody else on the island. But these are a bunch of teenagers, and who knows what's going through their minds, to be honest. But they left him, and at some point, his mother, God, please help her. She realized that something was wrong, and she contacted, the victim's best friend and said, where the heck is he? And that's when people are like, oh shoot, where is he? And they realized that they had his phone, and apparently, and this is odd as well, they were able to access the phone. When I say they, I don't know who they is. I've just read the reports. And I know that the mother and his sister, the victim's sister, were able to access the phone. And they were very suspicious that there were messages in the phone that were deleted. Specifically, they talk about the Snap app. I know that there's certainly a generation that knows what Snap is, and it's kind of like Facebook or Instagram, and you can message back and forth, and the messages are believed to disappear after a certain period of time. But I'll tell you, as a former prosecutor, they never disappear.
They're not gone, people.
Database. Yep, they're stored in a database on the East Coast. I used to subpoena Snap and TikTok all the time for those disappearing messages, and I would get them every single time. So, if there are any messages that were deleted, trust me, law enforcement is going to get them.
We will know.
That's right. And so, the mother and the sister are suspicious about what's going on. Okay, now fast forward a little bit, and there was an autopsy done. And the person who did the autopsy in Mississippi has a lot of credentials. I looked into his background, and there was nothing in his background that would make me feel like he wasn't qualified to be the pathologist doing what he was doing and making the decisions that he was making. And the family took thetheir case to the media, and they got help and funding from Tyler Perry and others who put out $100,000 reward for the arrest or capture of those responsible. And also they paid for the second world famous pathologist in Washington, D.C., who also took a look at the body. So let's talk about first, the victim's body, the original pathologist, the state pathologist in Mississippi, stated essentially that there isn't enough information yet for them to determine a cause of death. And again, that's very normal in these types of cases. So what they're doing right now is they're testing the lung tissues. They took the lungs and the trachea for testing. The trachea is, one of the tubes that goes down your throat here. And they're going to be looking for microfractures in the ligatures on the trachea, the cartilage, to see if there was any strangulation, any breaking of bone or cartilage or tendons in that area. And until they have the results of that, including the toxicology, there's not going to be a cause of death. And the family hired a very competent and one of the best pathologists in the nation, if not the world, who also took a look at the body without the trachea and the lungs. Now, he said in his report, obviously it's very common to keep those organs, and that doesn't mean that Mississippi is doing anything nefarious. But what I thought was interesting about his preliminary report, Claudia, was that it was almost the exact same as the pathologist in Mississippi, namely that they just don't know. They cannot determine the cause of death. They cannot determine if it was murder, homicide, natural causes, or what have you, drowning, alcohol intoxication, drugs, whatever. They just don't know. And when you have a case that started out so badly, with the Mississippi police, the police department in that small little town, saying without evidence that there was no nefarious conduct, that just rubbed everybody the wrong way, objectively speaking here. So that's where we are today. I think that we're all still waiting for the evidence. But Claudia, what are your thoughts?
I want to start with the law enforcement missteps because I agree with you. There were missteps. And as you said, that doesn't necessarily mean there were nefarious intentions. And I know that because I'm familiar with a very small department, and not all small departments are bad, but they don't always get the types of cases that allow their officers to learn and grow about different types of crimes, honestly. And I know one where an officer was actually assaulted and the other officers bungled that case. So they're not going to purposely bungle their own other officer's case. It's just, they just didn't know what they were doing. So I'm glad that you brought that up and mentioned it because it kind of started everything off on a bad foot. I love also that you mentioned the cell phone because for me, initially, I thought it was bizarre that his phone was on the boat. But like you, my understanding is because they were in and out of the water, they were drinking, they probably just had on swim trunks or bikinis if there were girls out there or guys that like to wear bikinis, whatever. They left their cell phones on the boat because they didn't want to carry it around. They didn't want it to get waterlogged, wet, whatever. So that makes sense to me. And the autopsies at this point make sense because there's still so much to be done. We have no toxicology yet, so we don't know. And I think you said it earlier, we don't know what we don't know yet because we don't have all the answers. And I feel like people are really jumping to conclusions when we don't know yet, because if you already believe if you believe he was murdered, let's say, you have decided in your mind he's murdered. So if all this information comes back and says, oh, he was heavily intoxicated and he drowned, are you going to accept that? I think it's very dangerous when we make a determination so emotionally from the start, and then it makes it hard for us to accept whatever other evidence comes through, because now we have that confirmation bias. So we're just going to say everything that, supports what I believe is right, and then I'll just figure out a way to twist everything else so that it doesn't take away from my belief.
Yeah, and you make a great point that once you you bring certain factors into a case, such as this, and certain areas of society begin having their own opinions about this, it really begins to taint the entire process. And I'll give you an example here. So, the family has hired a very well-known civil rights attorney, and his presence there, implies that there's a racial bias component here. And I think that his presence alone is the reason why the FBI got involved. The FBI, the only reason why the FBI would be there for two reasons. Number one is because the state authorities invited them because they don't have the resources to conduct an investigation like this. And number two, if there is a racial component, a civil rights component to the murder, if there is one, then it becomes a federal case, because a murder doesn't become a federal case because there's a murder. There has to be a federal jurisdictional component. The FBI works for the U.S. Attorney's Office. They don't work for the DA. This case has blown up into something that it maybe shouldn't have been blown up into, but for the sheriff, the local law enforcement concluding at the very beginning, without evidence, that there wasn't any nefarious conduct, that there wasn't any suspicious conduct, without having the evidence to back that up. So it's their own fault that there's maybe a mountain out of a molehill here.
I want to bring up one other kind of generalization here, Josh, and get your thoughts on it. And I don't know if this is true or not, but I know allegedly the friends are cooperating. Nolan's friends, the other people that were out there, are cooperating. I don't know if any of them have secured attorneys, but I want to address that in case they have or they do. Because a lot of people think, well, what are they trying to hide? They must be hiding something if they went and got an attorney. And I just want to say no. Because let me tell you, and I'm saying it for the world here, and I've said it before, if my husband dies tragically, the first thing I'm going to do is go get an attorney, because I know what law enforcement does. I know that I'm the first suspect, or the second if somebody else found him. But I know how those things work. And so for my protection, I'm going to get an attorney first and foremost. So if any of that ever happens, I'm calling you. But also, and he's said the same thing. Like, that's the first thing we're going to do, because it's about protecting your rights, protecting your interests. What are your thoughts on that?
Great point, Claudia. Every person on that beach right now, on that island, has a target on their back. The family has stated that they are suspicious of his friends. In fact, they were even more aggressive with their language, going as far as blaming them for the death of their son. Through reasonableness and common sense that law enforcement is going to have to exclude them from suspicion. What does that mean? It means that they are suspects until they're not. They need to be investigated thoroughly to be determined whether or not they were involved in his death, and if they were involved, to what extent. So you have to lawyer up at this point. It kind of reminds me of the Duke lacrosse case, where you probably had a lot of the Duke lacrosse players thinking that, I'm not going to get in trouble. I didn't do anything wrong. I was just at a party, and I know that nothing happened at the party. And then they all get prosecuted, right? And convicted. Many of them were convicted. It was overturned later on. It was proven that the accusers lied about everything. But that didn't protect them from law enforcement. That didn't protect them from being prosecuted and their reputations ruined forever. None of those kids now can get jobs because when you look up their names, you still see all the first articles that came out saying that they did all these horrible racially hateful things to somebody, which they never did. And it was proven that they didn't do that because the victims, I say that very,
The complaining witness.
The complaining witness, came out and admitted that she lied.
She did.
And did so because of the money, right? And I'm not saying that's the case here, but what I am saying is that if you're a parent and you see that your child is around something that is as hot as this, a homicide, a potential homicide, you have to protect your child. And it doesn't matter if you're black, white, brown, whatever. You're going to protect your children the same way. And you're on a beach. Your kid's on a beach where somebody who is associated with your friend, a fellow friend, dies in mysterious ways. And their family, the victim's family, is calling out for justice and vengeance. Like, you have to protect yourself. You really do. And the only way to do that in our society is to hire a competent attorney.
I completely agree with you, obviously. And I love the callback to the Duke lacrosse case. I followed that case from the very beginning. I just recently watched a documentary on it. And I know those kids' names. Well, they're not kids anymore, but I know their names. I also know her name. And she actually went to jail or prison. I don't know if you knew that
Oh,
for
yeah.
I can't remember if she was actually found guilty of manslaughter or murder, but she killed her boyfriend at the time, I believe, stabbed him.
Wow.
So she went to prison. She recently got out. But just to be clear, and you said this, Josh, she herself admitted none of that ever happened.
Exactly. There was a financial motive. She followed it through all the way to the end. She had a very unethical attorney who was helping her out, and an unethical prosecutor who I think was either disbarred or at least suspended for his actions in the case. And it was a travesty. But the moral of the story is protect your kids.
Yes.
Lawyer up whenever somebody is in trouble. It's not an admission of guilt. It's not a sign of guilt. It's actually a sign of competence. You have to protect your children and yourself and your family at all times, especially in a high profile case like this.
Josh, I think that is a great place to end this conversation for now because we don't really have any other information at this point. So I think that we will pick this back up when we get more information, whether that is from the cell phone dumps, from the Snapchat warrants, from the autopsy, all those places. We got a lot more evidence that will come in that will help determine what really happened here.
Exactly. Just a closing thought. We're all on the same side here. We want to find out what happened. We want justice for the family if something nefarious happened to their son. But let cooler heads prevail. It's not a gift to the family to say that their son was murdered and get them all upset when we don't know that. If the mother later finds out that it really was an accident, or it wasn't, it was just natural causes. She's not going to feel happy that she helped prosecute some innocent people, and she's in a grieving state. And when you're in a grieving state, it's always easier to kind of blame somebody for that, because it pulls you away from the grief. The anger gives you that short-term relief. And I feel so bad for the family, and I say, let's just let the process develop. The FBI is involved, and if there was anything suspicious or nefarious I think that the FBI will find something.
I think you are 100% right. The case is in the right hands. We will find out what happened to Nolan, whatever it was. And if it was nefarious, then we all want those people prosecuted.
Exactly.
Absolutely.
To the fullest extent of the law.
100%. Well, Josh, it has been a pleasure as always. Of course, I can't wait. I think we have a really exciting couple cases to chat about next week. So this is No Contest, the Kolsrud and King Report. For Josh Kolsrud, I'm Claudia King. Have a great night.